14th Texas now in session. Pursuant to the government, vouchsafe the Constitution and this honorable court.
Please be seated. Good afternoon, everybody. Welcome to the 14th Court of Appeals. We have one case on the docket today, number 1423-31CV, RDF Agent LLC and others versus Electric Red Ventures LLC and others. We have 15 minutes per side. Would the appellant like to reserve any time for rebuttal?
Yes, Your Honor. Cameron Pope for the appellant. I'd like to reserve 5 minutes.
5 minutes. All right, if we're ready to proceed, proceed when you're ready, Mr. Pope.
Thank you, Your Honor. If I may it please the court. This case concerns claims against a former New Yorker, Brian Sedrish, who now lives in Florida, and two New York companies that he works for, arising out of a potential loan financing of a $230 million transaction in an Arizona real estate project, and a term sheet that's governed by New York law and that doesn't require any of the appellants to do anything whatsoever in Texas. This case also involves a parallel New York proceeding in which appellees do not contest jurisdiction, and the New York trial court has already dismissed their fraud claims with prejudice and has recently ruled in RDF Agent's favor on all of its claims.
I'm sorry, could you repeat that last clause?
Sorry,
Dismiss the fraud claims and...
with prejudice, and recently ruled in RDF Agent's favor on its claims. So this case does not belong in Texas, to be honest. And there's no jurisdiction here. As you can see from their evolving pleadings, if you track through their pleadings, you can see they're trying to get a jurisdictional hook as they go along. They start out with the original petition, that's only against RDF Agent, and it's only for declaratory judgment regarding the term sheet, which again is governed by New York law and doesn't require us to do anything in Texas. When we file our special appearance and point out that, as this court has held on multiple occasions, contracting...
Let me ask you, going back to the New York case, I looked at the orders that were attached in the clerk's record. It appeared to me that the Texas case was first filed, is that right?
Yes, indeed, Your Honor, the Texas case was first filed.
Okay.
And that was brought to the New York court's attention, and the New York court said, well, look,
right.
that rule is not a wooden rule that you just apply rigorously without any kind of concern for what the underlying case, really the underlying dispute is. And here the underlying dispute is we want to enforce the exclusivity provision in the term sheet, and they don't want it enforced. And the term sheet's governed by New York law. That's the underlying issue, essentially, as to that part of the case. And so, looping back, their original petition was declaratory judgment regarding that term sheet, which is up in New York. We filed our special appearance. The very next day, they filed their first amended petition adding in these fraud allegations and related fund and Mr. Sedrish. Then we point out that you don't have any general jurisdiction allegations, so they filed a second amended petition, which is the petition that we're here on, with general jurisdiction allegations. And then we point out at a hearing that you don't have any veil-piercing allegations in there. Well, lo and behold, in comes a supplement with some veil-piercing allegations in. It's an attempt to manufacture jurisdiction. There's not really jurisdiction here. There's neither general jurisdiction nor specific jurisdiction. So I'll start with general jurisdiction because I think that's the easiest one to get rid of, the quickest one. Their argument there essentially is that a related fund consented to jurisdiction in Texas by registering as a foreign LLC and appointing an agent for service of process here. That argument, and then RDF Agent comes through as its alleged alter ego. I don't even need to get to the alter ego portion because a related fund, simply by registering to do business in Texas, does not consent to jurisdiction in Texas. Their argument rests entirely, as to this court, on a 1975 opinion called Goldwyn, and then they've got a First Court of Appeals opinion called Acacia Pipeline. Well, and they say, well, this court is bound, this panel is bound by that prior panel in 1975, which, is normally the case, except when there's a change in the law in the interim. And there has been a change in the law in the interim. I mean, you don't need to go back any further than 2014, for instance, with the Daimler versus Baumann case, where the U.S. Supreme Court addressed general jurisdiction. It said, no, principal place of business, place of incorporation. Which here, there's no dispute, we're incorporated. Both the corporate appellees are appellants rather, are incorporated in Delaware and have their principal place of business in New York. That's what you look to. And then 3 years later, they come back in 2017 in the BNSF Railway versus Terrell case and say, no, we really mean it. We really mean it. Just because the railway has 2,000 miles of track and 2,000 employees in Montana doesn't mean that you're subject to jurisdiction in Montana. Well, RDF Agent doesn't have any employees in Texas, and it has, Related Fund has 5 employees in a Dallas office that have nothing whatsoever to do with financing transactions like this. So the consent to jurisdiction argument is wrong, and in fact, in 2003, in a Zamaron versus Shinko Wire case, this court essentially tacitly threw out Goldman and said, no, it's just a factor to consider. Just that you've registered it to do business in Texas, just a factor to consider. It's not a card that you can play into, a trump card, if you will, that you win. And the First Court of Appeals last year, in 2022, did the same thing in a case called Devon Energy versus Moreno. They did the same thing. It's just a factor to consider. And because we're not incorporated in Texas or have our principal place of business here, there's no general jurisdiction. Moving on to specific jurisdiction, there's a fundamental disconnect in their argument. They say that all the appellants, including Mr. Cedric, who again is a Florida resident, are subject to specific jurisdiction here because you committed a tort in Texas. There's a disconnect there, though, because as alleged by them, and as alleged by them, we didn't commit the tort against them. We committed the tort, allegedly, against non-party Metastar. Metastar's not here. Non-party Metastar. If you look in their petition, the second amended petition at 579 through 581, that's their factual allegations in the petition. Each and every one of those is, you traveled to Metastar. Each and every one of those is Metastar. You traveled to Texas to meet with Metastar. You talked to you met with Metastar at their offices. You represented to Metastar. Again.
But weren't the appellees in the room when the alleged misrepresentation was made?
There's absolutely no evidence of that, Your Honor.
Okay.
There's an allegation later on in their petition, in the causes of action section of their petition, that's a generic, that says plaintiffs, you know, it's just a generic allegation.
And where did the misrepresentation, the alleged misrepresentation occur?
In Metastar's offices to Metastar, Your Honor.
To who? To what person was represented?
Well, as they allege, it's to Metastar. Now, again, they have this generic allegation later in their petition, but it's not been the law in Texas since at least 1967. In the Richardson versus First National Life Insurance Company, Texas Supreme Court 1967 case, says your specific factual allegations control over general allegations. They specifically factually allege, and I urge the court to look at those pages in the record. There is not one mention of any of these appellees on those pages. The factual allegations, they're missing. And this is borne out. It makes sense, because if you look at the affidavit they submitted from their New York real estate broker that came to us, that approached us in New York, he says, he's from the Carlton Group, he says, I am the representative and an agent of Metastar. I served as the representative agent of Metastar. Doesn't say anything about anybody else. He just says Metastar exclusively. And then they didn't submit an affidavit from Monza Harani, the appellee. They submitted an affidavit from Gino Harani. I'm not sure, obviously it's a familiar relation, but I'm not sure what it is. Of that term sheet that was signed. If you look at that, you'll see it says there's no obligations, there's no rights, liabilities, or obligations created by this term sheet, except for a few clauses, including the exclusivity provision, which is being litigated in New York. Except for those, and the right of first refusal is not one of them. It's at best, and on its own terms, is it at best an agreement to agree, and we don't even think it gets there. Because it
doesn't
says,
show purposeful availment in Texas?
no, Your Honor, it's directly contradicted by the prior statement in the term sheet that says this isn't an agreement. We're not availing ourselves of Texas.
All right, let me follow up on that question then. So, under the long arm statute, Texas courts can exercise jurisdiction over a non-resident if they do business in the state. And two ways you can do business are by having a contract with a Texas resident that's performable in Texas, or by committing a tort in the state. Okay, you've talked about those two things. Assuming that the term sheet is not binding on anybody or any part of it, if you have a non-resident who comes to Texas to attempt to negotiate a deal with a Texas resident, comes here, has a meeting, has discussions, and then ultimately the contract may or may not come to fruition, let's say it just doesn't materialize for whatever reason, why is that not sufficient to do business in the state, even though you've fallen short of actually getting a contract?
My time has expired. Can I?
You can answer that
No,
question.
we want to hear the answer.
Well, there's two parts to this. First off, if I come to Texas and make misrepresent and do business with
Let's
you,
assume you're right about the tort part. Okay, let's say there
we're
was
not
never
doing- sorry.
a misstatement. Let's say there was never a misstatement to anyone. Okay, so if we're just let's talk about what it means to do business in Texas if you don't have the tort and you've got something short of a contract.
Your Honor, we are talking about specific jurisdiction. We weren't doing business with them. That's the allegation. You can, if you have you can do business. If we were doing business, it would be under your.
But they did sign the term sheet.
Sorry?
I mean, didn't they sign the term sheet?
Which is governed by New York law and says it's not an agreement and is negotiated. But even if that were the case, we're not. It's what's the contact with Texas? We negotiated that term sheet from New York. We signed it in New York. It's for an Arizona real estate project. There has to be, in addition to the long arm statute, isn't the be all and end all, right? You go on to the next inquiry, which is this consistent with constitutional principles?
Right, but if you're right though about jurisdiction lacking under the long arm statute, then you would win.
Yes.
Without even proceeding to
Yes,
the other
we would,
prong.
indeed.
And so, I mean, my question is, because the list of doing business in Texas and the statute is non-exhaustive, why can't attempts to negotiate a contract in Texas still with Texas residents still constitute doing business in Texas even if a contract doesn't actually materialize?
Well, because this court has held on multiple occasions that merely contracting with a Texas resident isn't enough. We didn't even enter into a binding commitment to do anything, and if we had done, it would have been in Arizona. I mean, this court held, Your Honor, I think it was on that panel last year in Pappy versus Batra, where the court says, you can even have extensive, substantial contracting with Texas residents, and that doesn't submit you to jurisdiction. So merely negotiating the potential to get into a loan transaction, which all the loan documents that we were sending them were governed by New York law and forum selection and all the rest of it in New York, nothing to do with Texas. This case could have been anywhere. In the Parex Energy Resources case that the court decided 9 years ago or something, the court pointed out, yeah, okay, you made communications with Texas and you talked to Texas people, but the fundamental part of that transaction was you were buying, the party that sought to haul into Texas, you were purchasing non-Texas assets.
Except it also included a right of first refusal on Texas property, albeit still perhaps not completely consummated. It did also involve Texas property.
Your Honor, I would submit that there's no perhaps about it not being consummated. I mean, the very right of first refusal says, we'll agree to definite terms later on, maybe. And then up the front of the thing. And the right of first refusal would be to Metastar. These guys have nothing to do with the right of first refusal. It's a Metastar property under the right of first refusal. So again, they've got all these alter ego allegations against Related Fund and RDF that they're trying to hook us in, but somehow they seem to think that they're all one big blob and we should have, that the law requires us, just because we contacted Metastar, well, everybody related to Metastar gets to come into Texas court and sue us. That's not the law. It's never been the law.
All right, thank you, Mr. Pope. We'll hear from you on that.
Good afternoon. May it please the court, my name is Sharon McCauley, and I represent the
appellees in this case, Electric Red Venture, Mr. Mansouri, and Manfred Company, Harani. I have to start where this court started. You asked a specific question and you did not get a specific answer, Judge, and then I'm going to come to the framework. Who was at the meeting? See, everything they want to talk to you about today is that nobody was there. This is not about the plaintiffs. It's not about talking to plaintiffs who are Texas residents in the state of Texas, but you hit the nail on the head. Mr. Harani is a Texas citizen, and he signed the term sheet as an officer of both plaintiff Electric Red and an officer of Manfred. And he was a signatory to the agreement too. We have a consummated term sheet.
Well, you have an agreement to agree.
Disagree, Your Honor. We have signatures on a term sheet, and
Subject to consummation of final loan documents.
it is certainly, I agree with you, it is subject to final loan documents, but that does not mean we have not consummated an exchange of promises. And the way I know that is that they've sued to enforce the promises that are contained, they allege are contained within that very term sheet. See, what they're really saying is that the contract is not enforceable. They agree that it's been signed. But in Citron versus Menace, this court has said, it doesn't matter whether or not you allege that it's not an enforceable contract. If you had to prove it was an enforceable contract on the merits before you could use that contract for specific jurisdiction, you'd never get specific jurisdiction. It has it backwards under the due order of pleadings. We allege, that's what this case starts with, is the allegations. Only the allegations that are actually negated in this case do we then bring evidence of. So, as an aside, this idea that we have this evolving pleading thing, well, you bet we did, because it was responsive. When they filed an affidavit in response to our pleadings, we filed an amended petition to pick up all of their allegations. We have evolved petition to make allegations, and they have not specifically denied the very thing that you were asking about. We know that they contracted with a Texas resident, two Texas residents. We also know that the contract was being performed in the state of Texas because we made that allegation in the petition, and they never negated it in this case. So
what part of the term agreement or the term sheet is performable in Texas?
Exactly, the right of first refusal.
Okay.
The right of first refusal is performable in the state of Texas. It's essentially.
Except, how do you answer that the right of first refusal was flowing to MedStar, a non-party?
I just disagree with that allegation. What our brief shows you is the negotiations for the right of first refusal was something that the defendants themselves demanded be in the term sheet. In that term sheet that involved an Arizona company that Electric Red owned, they were importing Texas property into the terms. They would not sign, we took it out, they put it in, they would not sign that term sheet unless we included that right of first refusal. So it's not about whether or not it was actually enforceable, as I say. What it is that the negotiations and the direction of the contacts for purposes of specific jurisdiction is that they wrapped a Texas property into this. But that's not really the centerpiece of specific jurisdiction. The court has already hit on it. The centerpiece, and what they have no cases on, is that the contract, that the misrepresentations for the tort occurred in Texas. They were misrepresentations.
Well, what's the effect of the New York opinion throwing out the fraud claims?
Well, that's a really great question, Judge. It has no effect on specific jurisdiction, I can certainly tell you that. But their position is, first, that because we filed first and they've gone up to New York and gotten something on the merits, that they get to talk about the merits. Well, this court's standing opinions, Texas Supreme Court, you don't deal with the merits with respect to jurisdiction. But there's a bigger point here. What they're really trying to tell you is that you should not observe Texas longstanding principles for the first filed jurisdiction. You're right. We were the first to file. We have dominant jurisdiction in the state of Texas. And they want to disregard first filed by bringing you merits opinions without even resorting to procedural Texas cases on first to file. There are two exceptions to first to file under the Texas Supreme Court opinion in JB. Those two exceptions are the fraudulent or bad faith conduct of the first filer, which caused a delay in filing by the other party. No allegation of it, no evidence of it. The second exception is that we filed first with no intention of prosecuting the case. Clearly, we're prosecuting the case. For them to suggest that they, second filed, no dominant jurisdiction, can obtain merits opinions and influence this court somehow for jurisdiction is contrary to all Texas precedent in that regard. You have questions, sir? I'm sorry. So,
I have a follow-up
Okay.
question. Going back to the right of first refusal provision in the term sheet, why is that provision binding when, number one, the opening paragraph of the term sheet says that it's not a binding document, and number two, the right of first refusal provision itself says that the terms for that would be set forth in a future document. So why is that provision going to be binding?
well, my respectful answer to the question is, it's not material to your jurisdictional analysis
Okay.
whether it is binding or not binding.
Okay,
What-
but if it's not a binding contract, how can you have a contract with a Texas resident that's performable in Texas? That gets back to my question to Mr. Pope.
That's why I'm saying I think there's a distinction in what they're trying to tell you about whether or not we consummated a contract, a term sheet, and whether or not we consummated a loan agreement. This was not, the terms were fairly certain in this term agreement. That's how we term sheet, that's how we know they're trying to enforce it. But the analysis here is both a tort and a contract, okay? So the misrepresentations that they made in Texas to Texas plaintiffs were inducement for us to sign a term sheet that contained a right of first refusal. The tort that was committed led to the term sheet. So it's not, the court, your court, Citron, doesn't ask whether or not it's going to be an enforceable agreement, whether or not it's going to ultimately be held not to be a binding agreement, even under New York law. Although it's amazing to me how they think New York law or any law in the union is going to allow one side to enforce the contract, but it be not enforceable as to the other side.
So when the long arm statute says that doing business includes contracting with a Texas resident, that could mean a contract that's ultimately unenforceable.
Yes, Your Honor, absolutely. Otherwise, as I say, the policy analysis would cause you to have to look to the merits to determine whether or not that contract is ultimately going to be enforceable under any set of circumstances. And that's,
Okay. Yeah, that answers my question. On the tort claim, so again, clarify for me, who was present when the representation was made?
who was present, we know for sure, is
Okay.
Manzur Hourani, who is a plaintiff in this case and was a guarantor signing on the term sheet.
Okay.
He was also, I want to get it right, I don't want to lie about this. He was also known to these folks within the term sheet. He was known to be, I want to make sure I get it. He was the CEO, I believe, of Manfred. He signed in his representative capacity, that's really my point. He was in the room. Their affidavits show that there were other representatives of the company that were in the room. They're trying to tell you that, your factual allegations suggest that we were only talking to Metastar. See, they've disregarded the rest of our pleadings where, in the record on 585, we allege that the misrepresentations were made to plaintiff, and this court's opinions do not require that a misrepresentation be made directly to a plaintiff. They require that the misrepresentation be intended to induce, but more than that, the jurisdictional allegations can be made through an agent. Best case on that is, again, I don't want to lie, I want to give you the best case on it, is ERC Midstream. This court said it doesn't make any difference whether or not you are working with someone who is acting through. That actually was the specific language in ERC, exactly like it's the specific language in this case. Doesn't matter if you're acting through somebody, it's still, if you know and facts and circumstances reveal that the other party is an integral party to the negotiations or the discussions, then it doesn't make any difference for jurisdictional purposes. Those contacts are charged to you. That's exactly what we have. Electric Red had to be in the room or had to be a part of the negotiations with Metastar because they own the property in Arizona. Term sheet's nothing without Electric Red. So that's a problem with their argument. I can even back up just a little bit further and say the real problem with their argument is they're disregarding the standard of review. The standard of review presumes that all of these facts the court is asking about, that they were found in favor of jurisdiction. They're not telling you that there's no evidence of what we're saying. They're just trying to re-argue the evidence. So exactly those sorts of things. Were the misrepresentations made to the plaintiff? Is there evidence of it? You bet there is. Gino Harani's affidavit says representations were made to us while we were sitting in the room. Mr. Sedrich himself, in one of his 3 affidavits, says we were having discussions on the project that is the subject of the term sheet. So we know that Mr. Harani was in the room during that. It was happening to the plaintiffs. They are not crediting the inferred and actual facts that could have been found by the court. So if you just want a rehearing in the Court of Appeals on your jurisdictional analysis, then you're not applying the standard of review and asking this court for rehearing. That's not what this is about. There is no case, they'll bring you no case, haven't and they won't bring you a single case where somebody comes to Texas, they commit a tort, misrepresentation, they misrepresent to induce in the state of Texas on our soil, that they then consummate a transaction with Texas plaintiffs. A suit arises out of the very transaction that we're talking about in specific jurisdiction that isn't present. So they can't get past specific jurisdiction at all. And the best case for specific jurisdiction, of course, is for RDF agent. But we also have several other theories of jurisdiction I want to touch on quickly. I will make the segue to general jurisdiction, but if you don't mind, I'd like to get an off ramp just very quickly on consent jurisdiction, because we're having a real problem with their analysis on consent jurisdiction. And I hate to say it this way, but this is the way it is. There has been no change in the law in the 14th Court of Appeals. First, let me say, consent jurisdiction is neither specific nor general, so it's sort of a hybrid that's in the middle. It is a waiver sort of a concept. So they say it's just not the law anymore. See, the problem with that is that this court is bound by that 1975 case. And the only way that you're going to be able to get past consent jurisdiction in this case on the undisputed facts is to overrule that decision. The 114th Court decision that they rely on is not only a plurality decision, one judge, but it also comes back in a motion for rehearing and says it doesn't overrule the case that I'm talking about, the Goldman case. So there's nothing to suggest the 14th Court has ever overruled the principle stated in Goldman, and it's clear.
But Goldman was a general jurisdiction case, was it not?
I don't believe it was actually either specific or general. The principles blend. I concede that to you. The principles blend. But their consent jurisdiction, more often than not, they're saying it's not technically a specific or a general, which is why their Daimler case has absolutely nothing to do with this. Daimler didn't say a word about consent.
But Daimler says for general jurisdiction, you're limited to principal place of business and state of incorporation, and which doesn't apply here.
Right. It didn't say it was limited, but it said that's sort of a
except in the rarest of circumstances.
Right. I'm with you there. I agree. But
so do you agree there's no general jurisdiction?
I do not. I agree there's no general jurisdiction over Mr. Sedrich or over RDF agent. But I do not agree, and we're not even asserting consent jurisdiction over them. I agree that consent jurisdiction applies to related because they filed papers saying they were going to do business in the state of Texas. You want the privileges of the state of Texas, you take the burdens with it. That's what Goldman said, and that's what you're sort of stuck with. Even if you consider it a general jurisdiction, Goldman says that fact and that fact alone is the end of the analysis. You register to do business, the analysis is over.
I mean, it's either got to be specific or it's got to be general.
I would think so.
And the registration as having a registered agent has nothing to do with specific jurisdiction necessarily.
Agreed.
You could register for selling used cars. So that puts it within the general jurisdiction bucket. And Daimler says two things.
Well, I think, with all due respect, Judge, you may be giving me the reasons why this court would not stick with Goldman, but you're stuck with it right this minute. You will have to say that Daimler, by raising the bar on general jurisdiction, overruled Goldman under any set of circumstances because Goldman doesn't look to any other context. It doesn't look to purposeful availment. It doesn't look to anything. The only thing it asks is whether or not you registered to do business in the state of Texas, and they did. I see that I'm out of time. I'm going to have to rely on the court to read the brief on general jurisdiction. Appreciate the court's time. Thank you so much.
Thank you.
If I could, Your Honors, I'd just like to, I'll start at the end with the general jurisdiction and the consent jurisdiction argument. Your Honor's correct, it comes out of general jurisdiction. That's where it's supposed to come from. And counsel is correct that in 1975 the Goldman case came out. What she didn't mention, and I mentioned in my initial argument, is the Zamaron case, Shinko Wire, that came out of this court 20 years ago, that throws that out. To the extent Goldman was good law at all, it hasn't been good law in this, binding this panel for 20 years at least. Now, the plurality opinion, Zamaron is not the plurality opinion you mentioned, that's an earlier one, Conti Carriers. This court, to the extent it's bound by a prior panel opinion, and I will submit, I don't want to go over my arguments again about Daimler, Your Honors get that one, and BNSF. But it's not the law. Goldman's not the law in this case. And rightly so, because if you look at Goldman, which is a very short opinion, it's relying on a Donald case out of the Fort Worth Court of Appeals, I believe, that doesn't have anything to do with consent jurisdiction. They just made it up. It involves a Louisiana, it involves an accident in Louisiana. The facts don't matter, but it wasn't good law at the time, and it's certainly not good law in this circuit now. So we're not relying on a plurality opinion that's been overturned. That's just simply incorrect, relying on what the law is now.
Well, let's go back to specific. How do I deal with the fact that you're claiming, your argument is the term sheet's unenforceable, it's just an agreement to agree, it's just nothing, but then you sued to enforce it. How do I deal with that?
You know, we sued to enforce a specific provision in that. Not the whole thing isn't enforceable.
So you can pick and choose?
Contracting parties can contract however they please. I mean, we contracted with them so that most of the agreement is just as you would expect in a $230 million loan.
But I got an agreement that's an agreement to agree, and 10 provisions are nothing, but I choose this one and I'm going to sue to enforce this one provision?
The one provision that says it's enforceable, yes, Your Honor. If you agree.
Which provision was that specifically?
The exclusivity provision, Your Honor. It says, if you look at the front page of the front page, 726, it goes, essentially, nothing here should be constitute or be deemed to be constitute a binding agreement by our agent to do anything, essentially. And then it says, subject only to the paragraphs below entitled exclusivity and a few others that aren't at issue here. No rights, obligations, or liabilities of any kind or nature whatsoever shall arise on the part of borrower, guarantor, agent, or their respective affiliate persons or entities as a result of the provisions of this term sheet.
Okay, so I see you've got some separate provisions in here. The exclusivity and the out-of-pocket expenses provision are the ones that I see that say this section shall be binding on guarantor and borrower.
Correct, Your Honor.
So it was the exclusivity provision that you sued to enforce.
Yes, that's correct, Your Honor. It's essentially, I know they probably wouldn't agree with me when I characterize. I essentially view it as a time wasting.
I'm sorry, view it as a...
It's a don't waste our time provision. It's a $230 million loan. We obviously have, the way it works is we set up a fund. There's a fund. There's money committed. They want to do deals. Here they wanted to do a deal in Arizona, but it didn't come off. And you can see that we actually, if you look in the record around...
well, they paid you $350,000.
They didn't. Metastar paid us $350,000.
Well, you keep going, relying on the argument that Metastar was the contracting, was the real party with interest and not a party to this litigation. But Mansour Harani was in the room, correct?
Maybe. We don't know actually if he was in the room at some point. We don't know if he was there when these alleged misrepresentations were made.
But Mansour Harani signed as a guarantor.
Yes, John.
So and Metastar is not a signatory to the term
Sorry?
sheet. Metastar is not a signatory to the term sheet.
That's correct, Your Honor.
So, but Mansour Harani is a party, and he's an individual party, and he signed the document.
Yes, Your Honor. But let's not forget the course of... we didn't go into the meeting at Metastar and here's a term sheet, everybody signs it. That's not what went on. The record, if you look at 658, that's our email to them on June 28th. We send them an email, here's our draft. You know, we want Monza on it. The borrower, interestingly enough, is TBD. So the notion that we knew Electric Red was in the room 25 days earlier is preposterous. There's nothing in the record to suggest that we knew they were there. And they, again, we put TBD on the one that we sent to them, TBD borrower. And we put Monza on it, yes, true. And then they sent us one back on July 1st that, may I
Oh,
finish?
please.
Yeah. They sent us one back on July 1st that takes Monza off, puts Electric Red in as the borrower, takes Monza off as a guarantor, and has Manfred. And that's the first indication in the record of Manfred at all, July 1st. So nearly a month after this meeting where we supposedly knew that everybody was in the room. We cannot have an intent to induce, we cannot have the intent to induce element of fraudulent inducement if we don't even know who you are. Anyway, this court should reverse and render judgment dismissing from one of jurisdiction. Thank you very much.
Thank you.
Thank you, counsel. Thank you for your briefs and your arguments. The case is submitted, and you're excused, and we are adjourned.
All right.